206 up until what time we plan to go in this all-day provision?
Member Jackson, when last I checked the meaning of all, it means all. No, I think around 5-ish. Yes. 4:30? 4:30, 5-ish. All right, we'll see the pace at which we move. I think the other provisions, we can move a lot quicker. There are some submissions that we'll have to consider, but let's see what progress we make. Tomorrow, no. We'll come to that, Member Campbell Rodriguez. All right, let us move expeditiously. Over to you, Madam Director, Legal Reform.
Meaning we're going to Clause 5?
No, we're coming back to Clause 5. We're not making a determination yet. Remember, Madam CPC said she wanted to raise something at 5.1.
Oh.
We'll still do some thinking around it, but I know it will be subject to deeper discussion. Madam CPC, over to you.
Yes, thank you, Madam Chair. I was just asking that when we come to look back at 5, we should also, while we're considering in the meantime, look back at 5.1c, those last words where it refers to the judge of the parish court making a determination on bail in accordance with the Act. Looking back at it, I think the provision might have to be a bit more precise to specify or to link it to the factors that the judge needs to take into account in determining bail. Because right now it doesn't reference those factors.
Yes.
And then also to look at how that tracks back with Section 14.3c of the Constitution.
Yes.
Sorry, 14.3.
Yes. Member Campbell Rodriguez is just asking you to repeat the provision that you are commenting on. 5.1.
5.1c.
5.1c.
Yes.
Yes. Appreciated. We will flag it for modification.
Thank you.
So Chair, where should I are we at Clause 6?
Yes, I think we could go to Clause 6.
Okay, thank you.
Yes.
All right. The Jamaica Bar Association. Recommendation. The following have been recommended for Clause 6.1a and b. 6.1a should refer to the circumstances in which bail can be denied, which are in Section or Clause 7.1. One possible variation of that amendment could be, quote, a defendant is entitled to be granted bail by the deciding official.
Excuse me, sorry. Just what page are you on the matrix?
18.
Page 18.
To help you navigate to the matrix, in the first column, there is a section which is really the clause under consideration, and they're set out numerically. And then across the other columns specify the presenters and from whom the submissions have come with recommendations and comments. Right.
Okay.
So we're on page 18?
18. The comments of the Jamaica Bar Association on Clause 6.
So just for those who are listening, Clause 6 deals with the grant of bail after charge but prior to conviction. It sets out the entitlement to bail. It sets out the time frame that bail has to be considered once a person is arrested or detained. It sets out how a defendant who is charged with an offense that is not punishable with imprisonment is to be treated. And it also sets out how, in the case of a defendant who's charged with specified offenses set out at Part 1 of the second schedule, that bail can only be considered by a judge, similar to what exists now. So that is a clause under consideration. One, the entitlement to bail, and the time frame for consideration of the question of bail.
Oh, yes, sure. So the quote that they're proposing a variation. I'm just trying to figure out, is it to clause 7 or to clause 6? It's clause 6? Oh, a defendant is entitled to be granted bail by the deciding official unless the deciding official is satisfied that there is sufficient cause for reasons set out in Section 7.1 to hold the defendant in custody. That's a language that they're proposing.
So again, I defer to the CPC on how we are providing for the policy intent. So
they're just essentially saying that it should reference that it is the ones that are set out in 7.1. I think that.
Let me hear.
But let me
That's
finish
not
reading.
Necessary. I think
finished.
what is missing from most of the comments that we got in respect of the bill is that the bill is to be read as a whole. So each of the provisions tie back into each other. There's no need for a cross-reference there because 7 deals generally with circumstances where bail may be denied.
The bill has to be read as a whole. Laws are to be read as a whole. Is something we need to appreciate. Having said that, though, Madam CPC, if there is a way to just make it a little more reader-friendly without doing violence to the tried and tested principles of structuring the bill and the provisions around drafting, I know you will take those considerations into account.
So they go on. Since the term deciding official is not defined in the interpretation section to exclude officers below the rank of superintendent, the use of the term in this paragraph means that an officer at the rank of constable can determine the question of bail for a person who is arrested and charged. We are not certain if that was the intention. However, we urge a change from that position so that nowhere in the legislation can an officer below the rank of superintendent be the deciding official.
So let me speak to the policy intent behind that. And Member Jackson, it would also touch on a matter you had raised and a query you had made. As a matter of policy, we have drawn a distinction between the deciding official who is a police in the pre-charge regime and a deciding official who's a police in the post-charge regime. The reason we have not specified in the post-charge regime that the deciding official who's a police should be at or above the rank of superintendent is because of practical realities, that not every station has a police officer at or above the rank of superintendent. And we do not want to make it more difficult for defendants who would be granted station bail to not get it timelessly. And so we don't want to make it difficult that you have to wait for that superintendent to be called, etc., etc. Right now, as a matter of practice, police officers below that rank grant bail without issue. So it is my hope that the Jambar would understand that there is a proper policy consideration for not elevating the rank of the police for the grant of station bail to be that at or above the level of superintendent. We don't want administrative delays. Not every police station has such high-ranking officers. In the case of the pre-charge bail regime now, as part of the safeguard of ensuring that defendants who would fall under that regime are not lightly hauled in. We set it at the level where the area command would have knowledge of these types of people who are alleged to have committed crimes, because it's not every offense for which you're suspected that would cause you to come under the pre-charge bail regime. Not every offense. So there's a practical reason for it as part of the check and balance. One, to ensure that in appropriate cases post-charge, there is no delay, administrative delay, in the grant of bail to defendants who properly qualified and against whom there is no sufficient cause for keeping them in custody. And on the pre-charge regime is to ensure that there is proper accountability at a higher level by arresting and investigating officers for taking in someone and not being where they are not able to lay the charge against them within the 48 and 48-hour time frame.
Madam Chair,
Yes.
could we put a cap in the other direction? Because I think the fear may be that a constable, someone fresh out of the police academy, who doesn't have that experience necessarily, would be granting bail. So could we put a cap in the other direction that maybe, I don't know, I'm just...
You have constables
the
who are
constable-
well
oh,
experienced.
sorry.
Absolutely.
But that's
We
more an
Constabulary
administrative
Force Act,
matter. Yes.
It provides that it has to be either the officer in charge of the station or the sub-officer.
Right.
It
And
can't be anybody below that. So it
Okay.
has more to do with the responsibility that this
Right.
person carries at the station.
So, and
That
that's
it is
found where?
about rank.
And that's found where, you said?
Constabulary
The
Force
Constabulary
Act.
Force Act.
Okay, so it's
Yes.
already provided
Yes,
for.
yes.
So
Thank you.
remember, we've been at pain to say that legislation, no single piece of legislation exists and operates in isolation from a wider scheme. And we do have the Constabulary Force Act with provisions that provide guidance, even though that piece of law is up for review. And then there are also practical administrative considerations.
You know, Madam Chair, I hear you about the provision, and I hear Ms. Wilkins about the other provisions. Part of the reality that we have to face. When somebody is accused and go before the court, because the provisions are there, it is expected that the defending attorney would at least enter such provisions in the presentation before the courts. But I'm also told by practicing lawyers, experienced lawyers, that there are cases where judges, either, I wouldn't say unaware, but probably don't want to be bothered to go to those provisions. And in the midst of it, the accused person is the one who suffers. Whereas, in the act, by a simple insertion of the reference to provision, without repeating it, but just reference it, some of that could be remedied. It's the same thing which of the bill before that we struggled recently. I think is the Firearms Act, when we struggled to get the CPC to agree to not to repeat the provision, but just reference it. What I told you is not what I happen to know, but what people in the practice convey to me. So it's a reality out there. And, you know, persons suffer because of
But
those
bear in
things.
mind
So
that...
I just want to say, you made a point earlier on about the law being, you mentioned it easier to read, more understandable language to that effect. As we develop the legislation, the more we can make it more readable, and if there's such a term as referenceable, right, those pertinent provisions, then we need to make that provision. I want as much protection to be there for those who we as the state want to convict.
We are generally in agreement, but the proposal would have the unintended consequence of making the consideration of bail a little longer and a little more cumbersome. And that's not what really we want, because what you don't want is that you have a defendant against whom there is no sufficient cause for keeping in custody, but he can't get the bail because you have to wait till the superintendent comes. Right. No, but let's be mindful of the implication of the specific recommendation. So while we're speaking generally about it, it's important that we understand what it would mean if we accept that recommendation. And right now, we don't have a problem to be solved in that regard. Right. So just bear in mind that we can't make wide comments. We have to look on the specific recommendation and what would be the effect of accepting it. And I'm saying that if we were to accept it, then we may have an unintended consequence that does more harm than good.
Okay, I
Yes.
just
Right.
want us to be mindful of that.
Absolutely. Yes.
There may be, it may be worth considering, though, Chair, referencing is it 13? The Constabulary Force Act, because it would ensure that there is no doubt that when we speak of deciding official here, we're not just talking about just any constable. So it may actually be helpful. I'm subject to the CPC's position, of course, but it may well be helpful if we do some referencing to the provision in the Constabulary Force Act.
Member Jackson, the more you stay with us is the more you'll have cause to celebrate. Madam CPC, Madam CPC, may I throw it over for your usual careful consideration?
We'll consider, but the case is that the reason we usually put forward the undesirability of making those cross-references is because those laws, as you indicated, that act was subject to up for review. When it's reviewed and the provision or the numbering changes, then you're going to have an inaccurate provision in this current bill. So while I do appreciate readability, it's also, I think, more important for the law to be accurate.
Right. So just to expand on that, we have embarked on greater training of the police officers, bearing in mind the level of attrition, new people come in, and also just standardizing training and refreshing course. And I have participated in some since we have brought new arrangements to government. So what the CPC is saying that sometimes it is better not to make the reference in the law itself, especially if the law is under review, because you will have to make amendments. And that process of amendment, believe it or not, no matter how simple it is, it does take time. So what we will do is to just note it, and I will have some discussion around it and bring back some information to the committee. But to the best of my information, we don't have a problem in that regard. I think it is because of the provision for the pre-charge level where we escalated it up to superintendent that it sparked an idea. Because I did check beyond soliciting the perspective of Senator Sinclair, Member Sinclair, whether there is a problem there. And we really don't want to create problems, even if a suggestion sounds good and have a bigger issue than we would want. All right, so
that is being deferred, Chair? A decision on that is being deferred. Is that correct?
well, ultimately, I think we'll be guided by the CPC's approach, ultimately. But yes, we can defer it with a little note that we're inclined to the view to adopt the reason of the CPC, but we'll just give it a little further thought.
Okay. In relation to Clause 6.2, we again recommend that the question of bail should be decided by the police within 24 hours, not 48 hours. Rationale? This is even more important in this clause, where the offense in question is not punishable with imprisonment. If there are any reasons why a defendant who is charged with a non-imprisonable offense should be capable of being detained for 2 days, that should be stated clearly in the legislation. Otherwise, 24 hours is more reasonable for such non-serious offenses.
Let's just look on 7.5, Clause 7.5, which sets out when it would be sufficient cause would be shown to keep someone in custody who is not charged with an offense punishable with imprisonment. So seven five says that bail may be denied to a defendant in relation to an offense that is not punishable with imprisonment if it appears to the deciding official that, having been previously granted bail in any proceedings, the defendant has failed to surrender to custody, and there are reasonable grounds for believing that, in view of that failure, the defendant, if released on bail, would fail to surrender to custody. Let me pause to just highlight what we consider to be a careful design of that provision. So it's not any general failure to surrender to custody, because you may find that someone failed to surrender to custody because of a mishap en route to court or to the police station. That's not what we're talking about. We're talking about the kind of behavior that forms a pattern, which says by virtue of a previous action or omission, you are likely to repeat it. And so you would be in breach of your obligation to surrender to custody. So by using the word in view of that failure, it is taking it down to an even narrower consideration. It's not just that you didn't turn up on a previous occasion where you had very good excuse for not turning up, but it is the behavior pattern. The other thing is the deciding official is satisfied that the defendant should be kept in custody for the defendant's protection, or if the defendant is a child, for the defendant's welfare. Just to say that the Constitution does allow for deprivation of liberty as an exception for protection, and that is provided for at Section 14, 14.1G, 14.1G, and also part of it is at 14 in 14. Care and protection, in other words, for your own welfare. And then the other provision says the defendant is in custody pursuant to a sentence of a court or any authority acting under the Defense Act. That's standard and accepted in law and also in our current law. And then the other one is having been released on bail in or in connection with proceedings for the offense, the defendant is arrested for absconding while released on bail. So that it is in very defined circumstances that you can be kept, because in those circumstances, they would amount to sufficient cause. Where it is shown, it would amount to sufficient cause for keeping the person in custody. Any comment?
I just want to point out, though, Chair, that the issue with 6.2, it's not that bail would have been decided, it's that a 48-hour period before the question of bail is being considered.
I understand.
So they're saying if it's an offense for which it's not punishable with imprisonment, should this person not be treated with in a more expeditious manner? I think that is the cut and thrust.
I understand.
Okay.
I understand.
All right.
I understand. And I think we can consider it, but I also know the general posture is that leave it as is at 24, regardless of what the data has thrown up about the time that is required for the administrative steps to be taken. And we cannot exclude the propriety of administrative steps, because you have judicial review on that basis too. So sometimes we tend to forget that there's a proper place to allow reasonable time to deal with administrative matters.
It would be a minor offense, though, Chair. If
No,
we accept their
you have,
proposal.
no, man, it's not just minor offense you have punishable with fines. Not at all. Not at all. You have serious misdemeanors. Absolutely. Come on, Madam Director. Yes. Proceed. Yes.
What's the decision, though, Chair? What's the decision on that?
All right, we'll give it a second thought.
All right. Deferred? Okay.
Yes.
Jamaicans for Justice. Recommendation. The following are being proposed for Clause 6. It is recommended to amend the Bail Act. Amend the Bail Act. Okay. Under Clause 6 and remove it from the Child Care and Protection Act.
So we're not amending the Bail Act, we're repealing the Bail Act, and we are reenacting, we're rewriting, we're tidying it up. And, the extent of the tidying up was so much that we would have been amending practically every section, and that's why we have come with a new Bail Act that has, because it really is untidy when you have an amending bill that amend every provision of the previous bill. You just rewrite it in that case for smoothness and cleanness. And I think that point was lost on some of our presenters who submitted that the status quo should remain, just amend. But again, there are other considerations. Because we have the law revision exercise that has to be done following the passing of an amending bill that is read and construed as one with the Principal Act. Yes. Proceed. You see, these things jump out at me for accuracy. And I bear in mind that not everyone is an attorney, and so sometimes things will come. But part of this process is also to help educate the listening public.
Okay. Having regard to the resources of both offices, the CPSFA and the Children's Advocate should be mutually responsible agencies ensuring the care and protection of a child, and this should be specifically stated in the Child Care and Protection Act. I think there might have been an error. They may have meant the Child Care and Protection Act in the first one, but I would read on.
You see? So they're saying amend the Bail Act under Section 6 and remove it from the Child Care and Protection Act. What does Section 6 of the Bail Act say? First of all, it has to be understood that we are not amending the Bail Act in the strict sense, though we are tidying up provisions that are being retained in this new law. Well, the head of JFJ is a lawyer, you know, so, right. Having regard to the resources of both offices, the CP, SFA, this is the office that is now embroiled in controversy?
Yes. Sorry,
I see.
Chair, may I?
Yes.
I think it should have been a reference to Section 67 of the Child Care and Protection Act. There were, right, so Section 67 of the Child Care and Protection Act, the marginal notice, bail, or detention of child, where a person who is apparently a child is apprehended with or without warrant and cannot be brought forthwith before a court, the officer or sub-officer of police in charge of the police station to which the person is brought shall act in accordance with subsection 2. So I think they were using the opportunity of a discussion about bail to raise that particular issue of concern to them.
Thank you for the clarity, Mr. Foreman. And this leads me to a point that, Mr. Foreman, bring the mic closer.
Right.
Or
They were paying attention to Section 67 of the Child Care and Protection Act, which provision deals with how to deal with bail in the context of children or someone who appears to be a child. So my point was that I think they were using the opportunity of a discussion about bail, broadly speaking, and under the bail bill specifically, to raise a concern about bail in the context of children under the Child Care and Protection Act. So the committee would have to, it's not, that's not the law that's before you. So your ability to, you can't amend it, but your ability to make recommendations is limited. And beyond that, I suppose you can consider and make recommendations in your report and things of that nature.
all right, let me translate that for you. Right. So again, for the listening public, that laws are assigned to portfolio, and there is a process by which subject matters within portfolio are dealt with. And so one minister can't just jump into another portfolio and make changes. There's a process that you have to go through, and that's for the good ordering of government. But secondly, I notice, and I'm speaking generally now, concerns being raised about children in custody. Many of the concerns are valid concerns, but I sometimes find that they seem not to sufficiently consider the extent to which children are in need of care and protection. And in those circumstances, there is a proper place for the children to be taken into state custody. Let's not conflate it with the issues around state custody now. We're talking in principle. And that the Constitution itself does provide that the liberty of a child may be taken away of a person who has not attained the age of 18 for the purpose of his care and attention. Sometimes because of the experience, we tend to forget the principle. So the principle is that it is constitutional and lawful to take a child into state custody for care and attention. So I don't know, I'm not able to give a more considered view on that recommendation, but even as it stands, it's important that it be recalled that there are good reasons. It's not just because of bad experience. There are good reasons for the provision. Many children are without homes. They are without shelter. They are without family connection, where even if the mother is not available, somebody else in the immediate family can take them in. And they linger and loiter on the street. And all kinds of unfortunate consequences flow. All right, so we're not amending the Child Care Protection Act, and whatever legitimate concern there may be in that is not a matter for this law.
Yes, Chair.
Right.
And what follows is a proposed text of what the amendment should read,
Right.
which involves a procedure that definitely would require engagement of all the agencies, which would be outside of our scope.
Chair, if I may, just for completion,
Yeah.
clause 3, 2 of the bill, it essentially reserves the question of bail in the context of children to the Child Care and Protection Act. So the question of bail where the defendant is a child shall, unless otherwise provided in any other act, be determined by a children's court in accordance with the Child Care and Protection Act. So, however, that subsection 3 shall apply in respect of the provision of surety by a parent or a guardian of the child.
You seem to be dropping your voice, Mr. Foreman. We value every word, so you have to keep.
I'm just pointing out that clause 3.2 of the bill makes a reference to the Child Care and Protection Act in the context of dealing with children in this context.
Let me just add to that the reason why clause 3.2 is provided for in the way it is provided for, Member Jackson, is because you do have children that can be charged alongside adults in the gun court and are treated according as adults once they reach the age of criminal responsibility, so that you have to have regard to those provisions where the child is being charged alongside an adult, and so that would be the court that has jurisdiction. That is why the unless otherwise provided in any other act is there. But the general provision is that they would be determined by the Children's Court in accordance with the Child Care and Protection Act, which gives primacy to the best interest of the child, but also having regard to established principles of dealing with child offenders, particularly in Jamaica, where they are charged, where they have attained the age of criminal responsibility and they are charged alongside adults in, for example, gun crimes. Right? Proceed.
So we'll proceed to the next recommendation.
Recommendations would not be accepted.
Yes.
It's a general
Not accepted.
consensus. Yes.
Yes, outside of the remit
Right.
of this.
Question, because another committee that I sit on, matters have come up which are not relevant at that time to that specific committee, and a recommendation is given that the recommendation be sent to the relevant minister/ministry, so that at the time when the particular legislation is being reviewed, it is on record that this has been sent over. You know, using the whole principle of tied-up government, is it possible for us to make a recommendation that this recommendation be sent? Because I remember that the CPA is one of those, along with domestic violence, etc., that are slated for review in the future. So could we have this recommendation sent over to that ministry?
My considered view is that the recommendation needs to be reconsidered, and I wouldn't be sending it over in this form. All right. But as a general rule, as we stated in the minutes of the last meeting on page 8, that the chairman asked the Director of Legal Reform to ensure that competent authorities were provided with a response on any recommendation that was considered by the committee to be a merit, but was not required to be addressed in the bill. So as a general principle, that is the posture and direction of this committee under this chair, which addresses the broader question of making the recommendations over. But the narrower question, I think that the group JFJ is vigilant in their oversight. And this matter, I would recommend that they just think it through a little more and send it in the right direction. Okay.
Minister, I don't know what the recommendation would be. I must confess.
That's it. That's why
that
I say
recommendation-
I couldn't sensibly send over something in this form.
I would have to say to them, please.
Thank you,
need
Madam
You need to
Director.
conduct a review of the Child Care and Protection Act. That would have to be the recommendation.
Thank you, Madam Director. It is clear that you understand where I was coming from.
Yeah.
Thank you. Yes.
Okay. Amend clause 6.1 to include the deciding official must consider the following factors when determining sufficient cause under subsection A. A, the need to secure that the defendant surrenders to custody, the need to prevent offending by the defendant, C, the need to safeguard victims of crime and witnesses, taking into account any vulnerabilities of any alleged victim of or alleged witness to the offense for which the defendant was arrested, where these vulnerabilities have been identified by the official. D, the need to safeguard the defendant, taking into account any vulnerabilities of the defendant, where these vulnerabilities have been identified by the official. And E, the need to manage risks to the public.
All right.
Would that go to 6.1?
We can hear the views of members. I just find it interesting, and pardon my thinking aloud, that in one breath, the criticism is that the more we prescribe matters to be taken into account, the more it is viewed that we are circumscribing or fettering the jurisdiction of the court, and more is being asked. So the fact that these recommendations are being made, to my mind, support the view that it is always helpful to set out clearly what we believe ought properly be considered by the court in exercising their discretion. So let's look at it. So 6.1, clause 6.1 deals with the grant of bail after charge but prior to conviction. A defendant who is charged with an offense punishable with imprisonment entitled to be granted bail unless sufficient cause shown for holding in custody, and shall be held no longer than 48 hours before the question of bail be considered. And then it provides for offense not punishable with imprisonment. And the JFJ is saying amend 6.1 to include that the deciding official must consider the following factors in determining sufficient cause: need to secure that the defendant surrender to custody. So as a general provision, I think that is provided for at 7, which speaks to circumstances where bail may be denied. Deciding official is satisfied that there are grounds for believing that the defendant, if released on bail, would fail to surrender to custody. Commit an offense while on bail is the other limb. And third, interfere with witnesses or otherwise obstruct the course of justice, whether in relation to himself or other person. And JFJ is saying the need to secure, so the need for preventing offending by the defendant, need to secure victims of the crime and witnesses, taking into account any vulnerabilities, etc. If we jump over to 6.3, we would see those matters set out on page 9 of the bill. In deciding whether or not any circumstance specified in 1A exists in relation to any defendant, the deciding official shall take into account nature and seriousness of the offense, need for preserving public order, likelihood of threat to public order, should the defendant be released. And I just want everyone to note that, again, we have embarked on a more careful design of this provision, because it's not just preservation of peace and public order without more, is the role of the particular defendant in threatening peace and public order. Carefully designing the provision so that the court, no deciding official can say, well, public order has been threatened. No. You have to consider this particular defendant before you. How does he threaten that preservation of peace? Preserving the public order. So the need to safeguard the defendant, taking into account vulnerabilities. So we have generally the defendant's character, antecedent, association, and community ties. And those are matters. And then we also have the defendant's health profile. So we have issues around vulnerability. And in particular, going over on page 10, at the defendant's mental state, whether the defendant's mental state renders it unlikely that danger is posed to any person. So those, we provided for vulnerabilities in the provision. Madam CPC, may I have a comment from you in response to this recommendation?
Sorry, Madam Chair, what was the recommendation specifically?
The recommendation, page 19, under the Jamaican for Justice, recommendation to amend 6.1 to include the matters itemized A to E. I've just gone through what we provide for that cover the issues raised. But I'm just asking you to just look at their recommendation. Practically everything is provided for in other ways,
Right.
and probably more generously.
Yes, I mean, we could look to see if there's anything that wasn't covered.
Right. All right. All right. So in respect of this recommendation, of the factors to be taken into account, we will consider whether anything set out here is not already provided for in the provisions of the law. So we will defer, in effect, defer it. That's a decision. Defer for further consideration against what we have in the bill. Okay. So far, we have considerations from the Norman Manley Law School that have been seriously considered, from Jambar been seriously considered, from JFJ been seriously considered. See? And even from one or two of the individuals. All right. In addition, yes, no, I just say it as individual as opposed to entity. Member Jackson. When I can't help myself, you have to help yourself to help me. All right, let's proceed, please.
Okay. For Clause 6.3, it has been recommended to revert to the provisions of the existing Bail Act. Make clear limitations on the types of offenses that police can grant bail for, including the years for imprisonment. Other jurisdictions, such as Barbados, specifies police bail in this regard.
Do you understand this recommendation to mean in light of what we have provided for in the bill? Because the bill currently makes it clear that for some offenses, the police can't grant the bail. That's the police bar, if to borrow their term. So they're now saying that we must specify the offenses by virtue of the length of time that the custodial sentence is for?
Well, I'm a little puzzled because
Yes.
6.3 is saying that for the offenses in Part 1 of the second schedule, only a judge can decide these matters. And most of the offenses is a whole long list. I mean,
Exactly. Informed by the data of the
So we
type
pretty
of
much, yeah.
criminal misconduct that bedevils
Yeah,
or society.
so the police can't
Exactly.
provide bail for this very, very long list.
So you kind of understand why sometimes in the past I've wondered whether the bill has been read fully.
Yeah,
Yes.
this one is puzzling.
Right. I think we can not accept that recommendation. Because we already provide for it. It's not everything that the police can grant bail for. And we have an extensive list in the back. Yes. There is, to borrow their term, a police bar. It's not matters that we put before the police, but we put before the court.
But just for clarity, it says here the question of bail may be considered only by a judge.
Put it any higher. Which one?
6-3.
6-3?
Yeah.
No, man.
Isn't 6-3 you're talking about?
Yes. Well, the only would, in terms of interpretation, will tell you how the may is construed with the use of the word only. But I would defer.
Like
Mr. Foreman, you're smiling. So, Member Jackson, one of the general concerns raised around the government's declaration of its intention to amend the Bail Act is whether the government would be fettering the jurisdiction of the court. While the conversation was raging in the public space, we got some guidance out of our final court on decisions out of Trinidad and Tobago, in particular, recent, with the guidance. And when I say we take the guidance that the courts have provided into account, we take it. But let me ask the CPC to explain why she has drafted it that way. Madam CPC, over to you. Looks like the CPC may have fallen off from my seeing. I know there are all kinds of connectivity issues. Are you seeing her still on? Looks like she fell off because she was just on a while ago. But Member Jackson, but the use of may in this case is more helpful than harmful. All right? Yes. Mr. Foreman, you wanted to comment?
Just to say that the language is the same formulation in the
as what exists now, too. Yes, yes. And we don't have any issues around that, as to the best of my knowledge from the research we conducted. So that recommendation would be rejected.
Norman Manley Law School. The bill only places the pre-charge and post-charge The bill often places the pre-charge and post-charge defendants on the same level, removing the hierarchy between the two. It is submitted that this is an incorrect approach when one factors in the different statuses of the two sets of defendants. It is submitted that this approach is not reasonable, proportional, nor necessary.
That's what I understand the submission to mean. I'd like to hear the views of others. Mr. Foreman, no? So I think it's premised on the starting point that a person who is not charged is in a different category from the person who is charged. We start even earlier than that. Both persons are reasonably suspected of having committed offenses. And that's the starting point for the deprivation of the liberty. Right? The charge is something that comes afterwards because ultimately they are arrested or detained so that they can be ultimately tried within a reasonable time. So if you go back a little earlier, so we started a little earlier than they have started it, and say both sets of persons are persons who have been reasonably suspected of having committed offenses. And it is that basis that they have been deprived of their liberty in accordance with what is specifically provided for at Section 14, 1F, Lim 1. So I think their analysis begins a little down the road, or go back to the start. So no person shall be deprived of his liberty except on reasonable grounds and in accordance with fair procedures established by law in the following circumstance. Jump down to F, the arrest or detention of a person for the purpose of bringing him before the competent legal authority on reasonable suspicion of his having committed an offense. So our analysis goes back a little earlier, putting those persons. It's just that one is farther along in the process towards the trial. But both are being taken before the competent legal authority. And the competent...
I think it might have been a general comment rather than a
recommendation.
Clause 6 specific
Right.
comment.
Yes.
Looking back at...
Yes, and I'm
submission.
addressing it generally too. We're saying that their analysis begins with a charge and ours begin with a deprivation of liberty on reasonable suspicion of having committed an offense. Right. So it's the deprivation of the liberty that we're addressing. And the starting point is that you are arrested or detained on reasonable suspicion of having committed an offense. All right?
We go on?
So, yes, so we do not see the inconsistency in the approach because the analysis begins a step back.
Well, I'm thinking that it, as Mr. Foreman would have just said, it may have been a general comment which we can be mindful as we go forward that wherever the word defendant is used, that it makes clear that it is not the pre-charge or the post-charge person.
Well,
If
Miss
that
Wilkins.
if that comes up.
Say it again, Miss Wilkins.
No, I'm saying.
You know I'm
this may
just
have been a
teasing.
general
I'm just teasing you.
Oh,
You know I'm just teasing you
Yeah.
because of our out
well,
of parliament
well, you know that
deliberations.
I'm not.
Yes.
I'm not a fan of that word, but I'm just following on the comment made by Norman, the law
Right.
school.
But again, it's important that we point out where we are coming from in the analysis
Yes.
and how we view this thought, because it begins a step further and our analysis commences a step
Right.
at the beginning, ab initio, is where our in accordance with the Constitution at Section 14.
But the
1F.
statement that you just made about the deprivation of liberty,
Yes.
that is it in the? I was wondering if it's in the or we don't
14,
have it yet.
14.1. 14.1.
No, maybe it should go in the memorandum.
Yes, remember we have agreed to tidy up the memorandum. Yes.
So we go to Clause 7. The Jamaica Bar Association. It is being proposed that in Clause 7.1b, it's concerning due to its great potential for abuse. If the bill allows for the police to deny granting bail to a defendant due to it being impracticable to obtain sufficient information, we urge the committee to include an obligation for the independent deciding official to speak with the defendant with a view to ascertaining the information needed to decide on bail. Without such an obligation, the only information / account that would be presented to the deciding official is that of the arresting / investigating officer, which may not be
From
fairly.
Ms. Wilkins? What page?
Okay, it starts on page 19, Jamaica Bar Association, and it goes over
You're talking about 7 now. Clause 7?
7, yes.
Oh, I see. That's I thought. So
Sorry.
we're finished with 6.
Yes, we are.
Yes.
I'm sorry.
And the only matter that is detaining us with 6 is to consider the recommendation of JFJ in respect of the factors to be specified and just to assess them against what is in the bill to see if there's anything we may have missed.
Well, the Jamaica Bar Association's recommendation was deferred as well. The one in relation to, in the case of the offenses that are not punishable.
Okay, yes.
Yeah, the 24 hours rather than
It's
the
a no but
48.
further consideration.
Yes.
Yes. Right.
Okay, so I'll
Good.
read
So those-
7 again.
Just important that we know
Yes.
where we are on the clauses.
Okay, so I'll read 7 again.
Yes, please. Thank
It
you.
is being proposed that in clause 7.1b, that clause 7.1b is concerning due to its great potential for abuse. If the bill allows for the police to deny granting bail to a defendant due to it being impracticable to obtain sufficient information, we urge the committee to include an obligation for the independent deciding official to speak with the defendant with a view to ascertaining the information needed to decide on bail. Without such an obligation, the only information stroke account that would be presented to the deciding official is that of the arresting stroke investigating officer, which may not be fairly and properly presented for various reasons.
All right, let me just ask, tell me where in the current bail law this provision applies, because I know it is there in the current bail law. And it is
Section 4.1c.
Section 4?
4.1c.
1C. All right, so just to point out that it's not a new provision and to say that it's a matter that
4.1.
makes such good sense because people may be arrested or detained in any of many circumstances. And with a call that you bring them before the court as quickly as possible, notwithstanding the time that is provided to bring them to address administrative issues. You may genuinely find, as we have found, and I think Member Williams, as a practitioner at the bar, can attest, that sufficient time has not enabled the court to enough information to be brought. It may be someone from another jurisdiction. But what puzzles me about the form of this submission is what appears to be a lack of appreciation for the hollowed justice principle that you don't take a decision adverse to someone without hearing from that person. So I don't know, as a matter of law and practice, that the court would take a decision adverse to a defendant without hearing from the defendant, regardless of how soon or how late that defendant is taken before the court. It bothers me. Coming from, I mean, unless there is something I'm genuinely missing.
Well, an important distinction needs to be made. The
Yeah.
existing law didn't contemplate a police officer
Right.
at 4.1c.
Right.
It is talking about the court. The
Right.
court being satisfied that it has not been practicable to obtain sufficient information for the purpose of taking the decisions required by this section for want of time since the institution of proceedings against the defendant. So it's a matter for the court in the existing
Right,
law.
but remember how the whole scheme of the law is that even where the deciding official, who is the police, takes an adverse decision, it doesn't stop there, because they then have to take the defendant before the court for the ultimate decision to be taken on the question of bail. It's just a further facilitative step by allowing for station bail before it going to court. But the final decision on the liberty of the subject does not rest with the police officer, not under this law.
No.
Right.
For the period of time that the police is able to have this person in order to...
Yes, but
yes.
sometimes there was a matter that I dealt with on the last day of last 2021, there was a matter involving a high-profile international defendant who was intercepted in our jurisdictions through the Interpol process, implicated in the assassination of the Haitian president, Moise. And let me tell you something, it was difficult to get the information at every stage, because within the time frame that we had the matter before the court, the instability in the Haitian government was such that you weren't speaking to the same person twice. And we had to verify a number of things. So even where you would want to find out something that properly has to be taken into account, time may not allow, not because of any delinquency or tardiness on the part of the state official. And so, as a matter of principle, if you are not able, time does not allow you to get it, the court must weigh that into account. It's not a factor that is by itself determinative of the question of bail.
I don't think the issue is that it is not a reasonable situation. I think the issue is whether or not we can expect a police officer to exercise this discretion in a
judicious manner?
Yes. I think that's the point they're making. It's a court that does it now. Are we saying that do we honestly believe that a police officer of whatever seniority level is going to make a decision?
I do, Ms. Wilkinson, I have to say, maybe I'm one of the few people who keep hope alive, especially with the improvements and notwithstanding the serious challenges. Let me tell you, no, we laugh at it because, and sometimes we don't understand the harm that happens. It is true that we have serious problems. It's true that we have many examples translated into judgments against the state using taxpayers' money when, there is such great competition for the scarce resources. But we have to start having faith in our institutions.
Minister, you'd have to determine or set out somewhere what are the circumstances that would constitute it not being practicable. That would have to, I think, be done to give some more support to this. It's a big discretion that is being given.
Remember, the issue is not looked at in isolation. The default position is that you get bail unless. The position is that in order for the court to determine what amounts to sufficient cause for keeping a person in custody, the court must have proper information. Hollard principle, you don't make an adverse decision against someone without hearing from them. Hollard principle. So I'm not defending, I'm just saying that when we take things in isolation and we pick them out, sometimes the analysis is not as full as it can be and should be. And we have to be careful that we are addressing the right problem. That's all I'm saying. Yes.
I hear you, Minister, but whereas we can rely on the court to determine practicability, I'm not sure that the public would repose that confidence.
Same way they say about us. Same way they say about us.
Lawyers?
All of us in the public service. And in particular, those in the civil service. Same way they say. No, but again, it's not minimizing the challenges that are great. That's why, you see, members Jackson and Paulwell, I am noting so carefully the comments. Because you see, when that phase of the constitutional reform come about public sector and providing for the level of training, it's not just that you come with qualifications, but you must understand the ethos. Right? You must understand what it means to discharge functions on behalf of the state, where the tentacles of government stretch so far and tangle and mingle in everything. Because we want standard, but we're not prepared to put in the work to make sure people deliver to standard. And then they ball out oppression. We want accountability, but no one wants to hold someone else to account or be held to account. It can't work, so no sanky, no sing so. Yes. We can't be building our institution, and when we make progress, we're tearing them down at the same time. Training on procedural propriety is now mainstream in police training. Training on human rights now mainstream in police training. And since the Ministry of Legal and Constitutional Affairs has been established, every new piece of law has some public education and special training. We began with the Firearms Act because that's the main one we worked on since the new ministry came in. And we've been doing lots of work to come, lot more, but we have started out on the right note. So if you're saying that we should consider whether we can reasonably expect the police, I'm saying, yes, I'm reasonably expecting the police, and they better well know they're expected to do right by the people.
Okay, let's see how that goes.
So this section that we're looking at, where this recommendation is being made, is section, we're looking at section 7, 1B. So, and it seems that the recommendation is really to guard against some abuse by the officers. In that context where a police has that jurisdiction to grant the bail, and the police could use that particular provision to say, well, I need to do further inquiries and do investigations, and so, in light of the circumstances, I cannot grant you the bail. Now, what is the difficulty with the recommendation, my lady? Because what it seems to be saying is that it seems to be recommending that we add a clause which...
Hear from the defendant.
Pardon me?
Hear from the defendant.
Yes, and to... No. What it seems to be saying, I'm looking at the recommendation here, and I can be corrected. It is saying that we should include a duty to ensure that the investigation to gather information, make inquiries, or prepare the necessary report is conducted diligently and expeditiously, where they have need to decide on bail. So this will be putting like a duty, imposing a duty on the officers. So so the recommendation is to insert this in the legislation, so at least to make the officers aware that that due diligence and expedition must be employed in achieving.
So tell me why we must specify it only in respect of this and not have them understand that is a general approach that they must take to their work.
Yeah, I understand
so,
that.
So a man will say, boy, something. Only in relation to this, them say I must do that in the law, So you know what? I'm going to take my own time. So the question is, where is the proper place to ensure that the expeditious approach to the work is done? That's the real question. Yeah. Because I don't think we can disagree with the concern raised by Jambar that any matter that the police is investigating should be done as expeditiously as possible to ensure that no prejudice results to a defendant.
Yeah.
Right.
But I personally, I understand, but I personally don't see that.
Just tell me now how you respond to that one. Boy, lawyer, you're representing the police officer, and him say, look back on it, are you passed the law? Look on it. Right? So, tell me, because that's a general duty that is placed on police officers.
Yes, I understand.
And it will come in the new Police Services Act, the JCF Act. But right now, it has been effected at the policy level until the law is updated.
But even so, where there is
and remember, you can have administrative review and judicial review on decisions taken at that level too.
Yes.
But you also have review built in this and appeals.
Yes. But I'm also thinking that if an officer takes, let's say, unreasonable time to gather this information and the accused or the defendant, is in custody, there would still be an option for the defendant to go before the court, because there must be a court. I'm thinking there must be a court date in between the investigation, because after you're charged, my experience is that you're given a court date. So if I'm charged and not granted bail on the basis that I need to get some more information, and we're talking about post-charge, then at least the defendant would have an opportunity on the court date, because at that time the judge will inquire as to, the question of bail will arise again.
So jump over now to a provision which speaks to the review of the decision of bail and new circumstances, the duty to review, and it says at clause 11 on page 15. A decision by a constable or a justice of the peace on the matter of bail to the defendant shall be reviewed by a judge of the court having jurisdiction to try the offense concerned. A, on the defendant's first appearance in court in relation to the offense. B, in the case of a refusal to grant bail or a decision to impose any condition in granting bail on an application by the defendant on any ground specified in subsection 2. C, in the case of a decision to grant bail or the refusal or the failure to impose a particular condition in granting bail on an application by the prosecution on same grounds specified. And the grounds are there has been a change in circumstances affecting the matter since the previous decision. There are facts applicable to the matter which were not available to the deciding official at the time when the decision was made. Because certainly when the results of the inquiries are thrown up, there may be facts that would not then have been in the contemplation of the deciding official. And we have specified it as a proper basis that has to be considered in reviewing a decision. So what I'm really saying is that schematically we have covered it.
Yes, so
we
that's
have
what I'm saying.
covered
So
it.
Section 11 provides a
Yes,
safeguard in
yes.
that particular context.
Absolutely.
Thank you very much, Madam Chair.
That's what I'm saying. That's why I always say, did you read the act fully? And if you read it, did you understand it? Right. All right. We're detaining Member Jackson.
No, I think I need bail application now.
I can't be a judge in my own cause. So you can't make it before me.
Ms. Wilkins, I'm appealing to you.
Right, Member Williams. So you got it. The matter is provided for in the provisions of the bill. Yes. So, not accepted. Yeah.
Okay.
Good.
All right. We go now to Jamaicans for Justice. In section or clause 7.1, it is recommended that it be amended to include at G7, if a defendant is denied bail in accordance with subsection B or C, the deciding official has a duty to ensure that the investigation to gather information, make inquiries, or prepare the necessary report is conducted diligently and expeditiously. Where they have failed to do so, the deciding official may be found in contempt. Rationale. JFJ raises concerns that seemingly...
Let's pay attention. We are on page 20, beginning on page 19, clause 7, we're dealing with the recommendation by JFJ. So it starts at the bottom of page 19 and goes over to page 20. Yes.
Yeah. So the rationale, JFJ raises concerns that seemingly the denial of bail on the basis of the court or prosecutor's possible negligence is being codified under section 7.1bc. JFJ acknowledges that time is needed to prepare to bring a matter to court, even in the instance of a bail application. This could involve gathering of evidence and the preparation of a social inquiry report speaking to the person's activities and associations in their communities. While this is recognized, JFJ emphasizes that it is necessary for officials to act expeditiously in their duties, and this must be clearly outlined in the bill. Therefore, a burden must be placed on officials to execute their duties in an expeditious manner, and where this is disregarded, some consequence must be applied. This is especially important as a lack of preparation by parties is a primary reason for the slow progression of cases through an already overburdened court system.
I have to say that I fully understand where JFJ is concerned, and the only issue is where we provide for it, but in a properly regulated service, police service or civil service. These are matters that speak to the general approach that you take. And I recall discussing with some of my constituents the pace at which the state delivers to the people. And a very provocative constituent said to me, could it be that it is because so many people in government service are only sitting down and collecting their pay, but are carrying multiple other jobs? And so they only devote part-time attention to doing the functions of government. You know, it struck me. It really, really struck me. Because when you think about it, something has been impacting the approach of our civil servants and our public servants to the work. How much time is dedicated to it, what it is. I don't know if that is the answer, but I would say to JFJ that I'm entirely with you on the need for accountability and the importance of our public officials and our civil servants in particular, or police officers, doing their job in a timely way. I would just say, though, that this is a matter that we will have to tackle frontally when we come to reviewing the public service regulations that are regulations of an order in council under the Constitution, which was repealed, but they were retained, and from which the staff orders and other things flow. I constantly struggle with where do we put it, because there is no dispute in my mind that we must get back to this place where those who are discharging functions of the state, and especially when fundamentally guaranteed rights are engaged, that they must act expeditiously. My one concern is our tendency to address good problems in the wrong place, and we don't get the results.
Madam Chair.
Yes.
I'm happy that there is some congruence between ourselves and that point of the need for it to be redressed. But where we part company is that it is not enough to, one, merely acknowledge it as lawmakers, acknowledge it, knowing that that failure has significant impact on persons' lives on a daily basis. And
so affect the systemic integrity.
One second. So we recognize that. I would not recognize it in a spurious way, sincerely, and wouldn't want it to happen to us. Wouldn't want it to happen to us, or even a distant third cousin. And if we would not want it to happen to us or that distant third cousin, then we, all of us, ought not to make it prevail. And so we have to find a fix, though not ideal. As I said before, where do you make it? Is it in the staff or orders, or the public service, or which other government entity? But to leave it there without an immediate fix, and I say immediate because we are doing the repeal of the Bail Act to put a new act in place. It is incumbent on us to fix it now. If at a later date there can be an effective administrative alternative, deal with it then. But we will stand indicted if we haven't acknowledged it, and I said the congruence between your position as raised by JFJ, we see it now, recognize it, share the concern, but we just leave it there. To leave it there, as I said, would be an indictment on all of us. So my humble recommendation, and I fully concur with JFJ on this, we must fashion a fix in the legislation. And I would want us, not necessarily to decide it here now, but we must ask our technical people to come up with some provision that can make for that fix, that somebody doesn't linger in detention because of these administrative failures or delay. So I humbly say, I'm not asking for a decision now.
Member Jackson, I have to say, between meetings, I find myself really reflecting deeply on the concerns raised, and particularly when the recommendation or concern is valid but just not appropriate for the bill that is before us. But our way of addressing that concern about feet dragging in the investigation is provided for, and I will ask the CPC to just look at how we can mainstream it. It's provided for in the factors that must be taken into account in deciding whether, how investigations are progressing. So when you look at 5.6, this is in the pre-charge bail regime. I invite your attention to page 5 of the bill, clause 5.6. 5.6b, stage of investigations and manner in which it has been conducted. And the reason why we put it as broadly as that is to ensure that it can be considered broadly and deeply. So we recognize the real challenge that exists to the credibility of the system because of concerns about how investigations have been done in the past. And I did say to you that we can look around and see improvements because we have had arrest, charge, trial, conviction in unprecedentedly short time in the recent past in very complex matters. So while we bemoan the challenges, it's important that we acknowledge the forward strides that have been made. So my comment would be that since the proposed law is making it clear that in assessing the conduct of the police around matters of bail and charge and timeliness, the stage of the investigation and the manner in which it has been conducted must be considered, then we can see just how we mainstream that provision, and we probably can add the expeditiously, because what is expeditious will be adjudged on all the circumstances of a particular case. So that's one way of addressing it. The second part of it is where do we provide for the treatment of the officer when he is weighed, he is found to be wanting in his approach. Let's give some further thought to that, Member Jackson, and see.
I don't want to straddle. I'm not suggesting to, to say not there fully in my mind in terms of the how, because you don't want a prosecutor or a police to be just dragging out the whole thing before the judge is able to consider the thing. And you don't at the same time want them to, you want to deny them doing the kind of, say they want information and so forth to come before the court. But it can't be, so I'm looking for somewhere recognizing the need for both sides, both for justice and the side.
So let's be clear now, it's really a short time frame that we're talking about because of how the law is structured. So the law does provide that where the court does not have enough material before it to make a proper consideration, it can delay through a denial the grant of bail until the material comes in. Right. So that is passed.
For that material to come.
And under this bill, certainly for consideration in the initial stage of getting it before the court, it's time bound. It's already time bound. Yes, time bound. And once it gets to the court, it is the court now that will determine what is timely thereafter, addressing all of the concerns and balancing the interest of justice. So that's why I say, sometimes we get very emotional because the concerns are real, but we still have to go back to the specific recommendation against the provisions of the bill and reading the bill in its entirety, not just picking out parts of it.
My concern expressed is not just in the context of the new bill, but in the context of the existing one.
It's not a matter from our research that has brought up any challenges.
Some of those have come to my app, but I'm not.
Right, but remember,
I'm not like Member Williams, who is in the court.
So remember, the existing law, and this law is that you can always apply for bail on any occasion. What we have done with this one in the tidying up provision is to say judicial time has to be used properly. So if there is no new circumstances, then it really doesn't make sense that you detain the limited judicial time to make applications that will go nowhere. So we tied it up to say once there is something new, a change between the last time and now, then that must properly be placed before the court and considered. And it can operate on both sides of the equation, of the justice equation. So the effort is to streamline it for greater efficiency and fairness on both sides of the justice equation.
It is recommended to repeal Clause 7.2. Rationale: the specific reference to murder and murder under ZOZO is concerning as a specified reason to deny bail to a defendant. The bill stipulates that the deciding official must be satisfied that the conviction of the defendant is likely, having regard to the strength of the evidence that the defendant committed the offense or offense is concerned. If the strength of the evidence is such that the defendant's conviction is all but assured, then it's likely the regular bail considerations will suffice to prevent the bail of such a defendant. One of the considerations for denying bail is the nature and seriousness of the offense, subsection 3A. If the disaggregation of murder and murder under certain circumstances is to account for the seriousness of those offenses, then this is provided for. The strength of the evidence that the defendant committed the offense is also provided for under subsection 3. G. 3G. Therefore, JFJ does not see the need for the additional punitive measure in subsection 2, whose purpose is served by other provisions within the same bill. Furthermore, the considerations under subsection 3 would more likely allow for bail to be considered in a case-by-case basis. It should be without the limitation on the subsection 2 that subsection 2 would place on that discretion. I hope that was understood.
All right. So I see that views on how we tackle the abnormally high murder rate and violent murders, as the views are divided. Let me attempt to clarify the Andrew Holness administration perspective. Our administration is of the view that for as long as the per capita murder rate remains what it is, we will take an approach that requires more than ordinary provisions to address the problem. The administration is also of the view that in the hierarchy of rights, the right to life is top tier. Because in the absence of life, you're unable to enjoy any of the other rights and freedoms. We're of the view that when we look at the rate of murder, the victims, the offenders, it really has left our society bleeding in many ways. The cost is not just measured in financial terms, high as they are. And we are in almost a battle for survival on this murder issue. Prime Minister Holness recently clarified his administration intention to, well, not clarify, informed of his administration's intention to bring some clarity around the penalty for murder, which at this time, in a worst case scenario, is still a sentence of death and then life imprisonment and a bastardization of imprisonment for a term of years. What he's clarifying is that what the law ought properly be is death and life imprisonment. And we will deal with issues around how much time you serve. When we looked at the data on the age of the offenders, it is that data that we use to determine, to give an indication of where our thinking is on the eligibility of parole. Because the view of the administration is that for those who choose to commit murder and are convicted of murder, not manslaughter, where you're on a charge for murder and the law recognizes circumstances that reduces it from murder to manslaughter. Once you're convicted, in this context, you're going to be separated from society for the rest of your useful life. We recognize that it's a view that, though understood, you may have dissenting perspectives on it. But in the scheme of offenses against the person, murder is still regarded as the most serious and most egregious offense in the hierarchy of things. And so when we carve out a special scheme for dealing with murder, we recognize that still ultimately we have to ensure that the court that is better placed to assess the matter has its discretion. But we are communicating how seriously we view this problem. But the seriousness of it doesn't mean that we are going to not be guided by reason in dealing with it. But from where we're coming from, there is no demilitarized zone in addressing this problem, while it remains what it is, causing the kind of collateral damage to the nation. Know how many children are growing up without mother, father, siblings. I mean, just when we think that we have heard the worst of the worst, some other murder comes that shock the nation. But it's as if we're growing used to it. Prime Minister Holness is saying, not under his watch. We will never accept this abnormally high murder rate as normal. Never. Yes, and I don't think... Yes, Member Jackson.
Much of what you say is premised on what policy there is. No one of us inside this chamber on either side or outside is saying that the high murder rate must be deemed tolerable. Nobody's saying that. And where you kind of lose me a while ago is it inherently suggests that those who don't agree with certain steps is giving comfort to the high murder rate. The 40% per 40 per 100,000. No, I'm not saying. I'm saying that the argument, because I hear it out there many times, not from your mouth. Let me finish.
The policy.
Let me finish. I waited. High rate murder is not tolerable regardless of the level of murders being committed in Jamaica. If it is 10 per 100,000, 40 per 100,000, whatever the amount is, it ought not to be tolerated. So you can't justify it because the murder rate is this high. It ought not to be permitted at all, even if it's only 1 per 100,000 per year. Because what you're doing is, because of that we're going to do this. No murder must be tolerated. No murderer the law must be sympathetic to. As you said, it differentiated between manslaughter where circumstances come in and so forth. So when the argument has been said, because the murder rate is this high, we must seek to deal with murders. There must be greater urgency because it's very high. But the steps that we take to deal with when it is 50 out of 100 must not be different from if it is 10 out of 100, per 100,000. We must deal with murders because it's inherently wrong, bad, terrible, and intolerable. That must be the premise of the steps we take. But when you say, oh, because the murder rate is high, we have to do these things. No, I don't buy that argument. We must deal with murders because it's inherently wrong. I have no tolerance for nobody's life being innocently taken. The only time it can be justified is in self-defense. If your life is not threatened by the next one, you ought not to deny anybody of their life. So it's intolerable. And that must be the message. We are intolerable of murders, period. We're not going to take this step because it is this. Because you know what happened? Intrinsically what it does is to cause people to become tolerant of things that they would not otherwise be tolerant of. Because it's so high. Murder is murder. Murderers are murderers, must be treated as such.
So I think every society recognizes that you're going to have killings, unlawfully. But I think where we part company is that because of the objective way in which the level is measured, meaning the per 100,000, and because of how high it is in our population, we do believe that we can't take the same approach. So whereas at a foundation level, any act of murder is frowned upon, we are of the view that we don't want to conflate or mix up the arguments because we are experiencing a specific problem at this time because of how high it is. So that's where we part company, Member Jackson, and I think perhaps that's where the Holness administration parts company from the PNP opposition on this matter. We do view the high murder rate as posing a specific problem above and beyond, even when you appreciate that murders generally cause problems.
I'm not saying that the high murder rate is not a specific problem to be dealt with. I'm not saying that. Of course, in previous PNP administration, to when the levels get abnormally high, right, we seek to deal with that. So in this period, where it is as high as it is, yes, there's an urgency to deal with it. The point I'm simply making is not to say these steps must be tolerated because of. That's simply the point I'm making.
Before you come in again, Member Rodriguez, remember prevalence of a particular type of offense is also something that we are tracking and the likelihood of that kind of offense being committed, but the provision is not cast widely. I get the sense that, because of the rhetoric around the murder, the provision, the specific reference to murder, the murder under the ZOZO is because a ZOZO is not an ordinary police operation. And when you have more police and soldiers in the joint army on the ground, and people decide to murder, that's a different risk they're assuming. Because the likelihood when you use violence in a context where your soldiers and your police are deployed in a concentrated space, more specifically, that kind of willful disregard for law and order is something that we're saying we note it, and we note it as requiring special attention.
ZOZO and SOE too?
Yes.
Madam Chair.
I mean ZOZO and SOE. Yes, Member Campbell Rodriguez.
Yes, thank you. I just felt the need to respond to Member Jackson because whether or not we like to admit it, we have a crisis with our murder rate. It is a crisis. And I want to use the example of a hurricane and regular rainfall. When the rain is falling, we respond with an umbrella. When the rain is falling, I won't say when showers are falling, I'll say when rain is falling, you respond with an umbrella or you close your bedroom windows. That's a regular thing. when you have a hurricane, and if it is category 5 versus category 1, you respond differently. That is what you need to do. And the murder rate in Jamaica is like a category 5 hurricane, which means you have to respond in a manner that can deal with the severity of the problem. And as such, I depart from Member Jackson when he says we should not say that because the murder rate is high, because it's a problem saying that.
Copyright that statement because I have to borrow it because it's one of the best analogies I've heard.
No, I love analogies.
The category 5.
Let
The
me tell you
category
something.
5.
Hurricane don't come every day.
It
Remember,
does not, but
no,
guess what?
but
Imagine if we
category
had a
5
category
hurricane has
5
been blowing
hurricane
on us
every
every
day.
day.
That is what our crime rate is like, our murder rate. It's like a category 5 hurricane every single day. So you're making my point. We must do things differently. We cannot behave as though we're having 50, 200 murders per year. It is different from when you're having the numbers that we're having. And a part of catching the criminals is ensuring that measures are in place that can address the problems we have. It cannot be, and we must stop pretending that it can be business as usual, because it's not business as usual. And we have to curb the scourge of violent crimes across this island before it gets to a point where there is anarchy. Because at that point, you'll then find that you're told the government policy did not take into consideration how harsh the situation was. And Madam Chair, I just want to say that I think the people of Jamaica in general, and I'm willing to gamble on it, are with us in taking measures that are a little outside what we're used to in order to curb the situation. So it is one of those things, I think. I remember earlier in the day we were talking about your minority view. I think, the way we're handling crime, taking the little pieces, I think the majority will support what happens. It's not a minority view in that sense. I think what Member Jackson is saying is a minority view in this instance.
I'd rather be right and be in the minority than to be wrong and be in the majority. You know what the people want? You want to be safe, yes, by catching the criminal out there. Every time we have this discussion, I remain fixed and mindful of the fact that as we speak, we have convicted criminals in prison, not out there running up and down, committing crimes.
Can you imagine how much worse it would be
if
they were walking around?
No. While we speak, the government, with all its authority of law and institution, is not stopping the people in prison that them are ready lock up from committing murders out there. What we need to do is to be able to apprehend the ones out there. That's what we need to develop the competence to do. Because you can't give them long sentence if you can't catch them. You can't talk about bail if you can't apprehend them. That's where we must focus on, them out there loose on the country. And we are not succeeding doing that. So don't tell me, give me comfort about dealing with the high crime rate because of what you're talking about, when you can't catch them out there. And some of them worse, you have them locked up in prison. And you, the government, allow them to be in prison, giving instruction to murder innocent people outside there. When you are able to deal with that, that's when you have moral authority to talk about controlling murder and reducing high murder rate. I'm not giving an opinion here. It's a matter of fact. The police can confirm it.
What is that?
It is, when I was, a couple of years ago, I was spokesperson, the police told me that one particular person, I won't call the name here, was responsible for 70 murders.
A violence producer?
A convicted criminal, not violence producer, convicted criminal in prison was responsible for 70 murders out there. So don't come with the fancy thing about violence producer and all them little fancy terms for get excited. The reality is that them in prison committing murder, and we, the government, is not able to contain that. If you can't control those where you have, or you try to control those where you don't apprehend yet. That's just ABC. You don't have to be a genius to say something wrong. Tell me what we're going to do to apprehend them criminals who are running up and down and making misery in our people's
Well,
life.
Member Jackson, a lot of things. Members Jackson and Campbell Rodriguez.
I understand you're trying to calm the fears, but I think using an exaggerated form of expressing oneself does not take away from the fact, Madam Chair, that you have to tackle the matter from different angles, and that is what this Bail Act is a part of that. And if we work together across the aisle and as a people, which is what the Jamaicans want, to see us working at it proactively, not just talking and being overly passionate, right? So that is what we're talking about. I've been here hours now.
Member Jackson. So, what an amazing learning ground this Joint Select Committee to consider and review the bail bill has been. So let's just, it's always important, in spite of the views expressed, that we come back to the specific recommendation that we're considering against what is provided for in the bill. So let me issue that reminder. But just to say, Member Jackson, that, you know what I am discovering more clearly is where there is convergence between the opposition and the government and where we diverge. That's becoming very clear. And to the extent that there are so many areas where we have a shared interest, we're going to be battling out competitively the positions we take to achieve the goals. And that's part of the politics. But it's also very clear to me that in spite of the similar concerns on both sides of the parliamentary aisle, there is still a great area of divergence between the opposition and the government on how to address the murder problem. And while that's understandable to a certain extent, it's going to be important for the government, which bears the responsibility of the general control of government, to clearly articulate where it's coming from. And I recall hearing something from the PNP opposition, which has stayed with me and makes me constantly question if therein lies the root of the divergence between the de jure and de facto leader of the party. It was said that murder was normalized at the, I can't remember if it's the 1,200, whatever rate in Jamaica. And so when the views on the use of emergency powers to deal with the violent crimes showing up in certain communities was considered, I think that probably is the root cause of the difference in approach. Because on the one hand, the PNP opposition is of the view that a high level of murder has been normalized in the society at a threshold. And we're saying on the government side that we don't accept it as being normalized. We will never accept it as being normalized. And because of that difference in perspective, we are going to take another path in addressing it. And more I hear expressions, is more and more I go back to that statement when it was said by the leader of the opposition, and also by a former minister of national security who sits in the Senate now. The more I listen closely, I believe that to a large extent explains the tension that is around this matter. One side views that abnormally high level has been normalized in the society and no need for extraordinary measures to address it. and the other side. I'm just saying it makes me wonder, because you can't dispute that the statement was said. You can't dispute that the statement was made, because it was made and it is on record. Hold on, don't bother come in, don't bother come in. You can't dispute that it was made and it is on record. Hear me now, I say. Turn your mic off. Hear me now, I say, right? Hear me now and say. The more I hear us talk about it.
Point of order. I think you said that somebody
You're taking a point of order against me.
A point of order, Chairman. You said earlier on that a defendant can't be denied bail without being brought to the court. You must not make aspersions and attribute things to persons who are not there to defend themselves.
No man, this don't need no defense, because it was said so boldly and publicly that when you make bold and public chat, you don't take it back and you're on record. So it's not a matter that I'm wondering whether it was said. It was in fact said.
It might be said, but context is also important.
Yeah. The context was specifically in relation to measures to deal with it, specifically in that context. And I'm saying that the Andrew Holness administration does not accept that a per capita murder rate in the high level where it is, and a nominal rate of over the 1,000 thing should be considered as normal. And that's why in seeking to address it in a time ban, we're saying that we have to resort to more than what is normal. And I think that's where the tension exists. And Member Jackson, think about it and let's have some more conversation, especially since this avenue is clarifying so many things, and we're seeing problems that are systemic coming up. So you and I are on the same page about the dialogue, and the dialogue is going to take place not only at the high level of the leaders, but also us who are influencers on our sides.
Madam Chair, with all due respect, that dialogue, again, you and I have congruence here. The dialogue is imperative, and the dialogue on the PNP has been called for and begged for an extended period of time. I have been officially the voice of calling for that dialogue before, and I can say on behalf of the opposition that that call remains, and it will remain so long as the problem remains with us. So I don't want you to give the impression it's only the Andrew Holness administration that deemed this to be intolerable. The opposition, PNP, has no comfort or support for the high level of crime being where it is, normalized where it is. It ought not to be there. So I don't want any impression to be given as if the government is alone in this intolerance for
that's not what I'm saying.
No. The country, the opposition is totally intolerant and unaccepting of the high levels of crime in general and of murders in particular. And it's for that reason why we have consistently said this we must tackle together. As we had shared in the earlier discussion in here, we must do it together, because it's not a government problem.
But that's not our point of departure.
It's a country problem.
That's not our point of departure. Okay. Our point of departure is that I have referenced a statement which was made publicly by your leader.
Let us stay on the path where we are together.
You see that? No, you don't want me to clarify. I say our point of departure is that a statement was made which I come back to every time. No, man, that's not trial in absentia. I'm not misquoting. I'm merely repeating what was said. Sometimes we would but I am also repeating the context in which it was said, Member Jackson.
I don't know the extent of the context that you are representing. He knows.
Yeah, man.
I don't even know myself.
The good thing is that this thing is on record, we're not talking privately. Yes, but I'm saying more and more. So if we go back to this now. So the provision is, the recommendation is that specific reference to murder in a Zozo is concerning as a specified reason to deny bail. It's a factor to be taken into consideration. It's not a reason of and by itself. And the policy rationale is what happens when the legal criteria are met for the declaration of a Zozo. Go back and look on the law. They mirror the SOE provisions. So when you have that state of affairs in an area declared as a zone, if you use SOE, the area would be regarded as a community. And someone brazenly act. So this consideration is not on its own, you know. There are other things that are layered on it. Right? Yes.
Yes, my lady, because it does say there that the deciding official has to be satisfied that the conviction of the defendant is likely, having regard to the strength of the evidence. So the tribunal, the deciding official, would still have to go back to the case and assess the strength of the case. And I think, if I'm understanding what JFJ is saying, is that if the deciding official has to assess the case, the strength or otherwise of it, and if the case is strong on paper, on allegations, then that in and of itself would be is the main factor for considering bail. So I think what they're trying to say is whether or not the offense is committed in a zone of special operation, the fact that let's look at a scenario. If a murder is committed outside of a zone of special operation, but the person comes before the court and the case is strong on paper and the judge decides that based on the strength of the evidence, you know, we are denying bail. Now, are we saying because it happened now in a zone of special operation that we have to now couple that with the strength of the case, or is it that we can still decide on the question of bail outside of the zone of special operation? You know, what I'm grappling with, my lady, is that I am of the view, and I see the policy, my personal position, I see the policy intent, and I see where we're going, because I understand the brazenness of someone trying to commit a crime where there's a state of public emergency. There's a zone of special operation, military, you know, joint military operations are happening on the ground. There's a cordon off area, and yet a crime is committed there. These, in my mind, are real aggravating factors to be considered in sentencing, which I'm sure, no doubt, that a judge, when it comes to sentencing, will consider these factors, you know, in terms of after conviction. So I see where JFJ, I tend to see what they're trying to say. You know, what if it is alleged that a murder was committed in a zone of special operation? There is allegation that a defendant committed murder in a zone of special operation, and that person is brought before the court. But the evidence is questionable, and a judge is not satisfied as to the strength of the case. Let's say there might be identification questions or issues, and the judge is not confident that the Turnbull principles would be, that will be satisfied. But it was committed in a zone of special operation. Or would that weigh on a judge's mind? Would the judge, would that tilt the balance against the Turnbull principles? So the judge will say, well, because this was taken into consideration, this crime it is alleged to have been committed in a zone of special operation. So, that's an aggravating factor because it's not a factor to be considered in isolation of other principles, Turnbull principles, reoffending, other aspects of the case. So that little aspect is a little troubling, but I think it is definitely, in my view, an aggravating circumstances in terms of sentencing.
No problem with that.
So, well, I think we can, look at it a little more. But I see I see the intent behind it, Judge. Because for a person to be alleged to have committed an offense in a zone of special operation, then this man is serious. It is serious, but we don't deny bail on that basis only. we would have to actually look at the other factors. And a judge will say, what's the case like, antecedents, and all the other factors that we take into consideration. So I think that's probably the point where JFJ is coming from. And because what they seem to be saying, what JFJ, having looked at it, I think what JFJ seems to be saying here is that, if it is that we already have a strong case, then we don't even have to consider whether it is in a Zozo era. We have already a strong case, so we are denying bail because we have a strong case. So it is taken care of in that provision where we look at the seriousness of the offense. I'm just throwing that out, my lady. Sorry, Madam Chair, just for consideration.
Thank you, Member Williams. I understand, Thou shalt not bear false witness against thy neighbor. Thou shalt not bear false witness against thy neighbor. Thou shalt not bear false witness. All right. So, Member Williams, I agree with what you said about your understanding of the submission. I think it accords with mine too. But that's not the end of the matter. Let me just invite Madam CPC. I think that this too needs a little tweaking. But I'll come to that a little later on. But let me invite the comment of the CPC. I know what the policy intent is. We are considering page 20, Madam CPC, of the matrix, the recommendation by JFJ in respect of what is set out there.
Yes, hearing all that has been said, I think the intention, notwithstanding any areas of overlap with what has already been specified in 3 about the nature and seriousness of the offense and the other factors, that the intention was to highlight.
Hold a minute. Member Jackson, please show me that you are listening and not being distracted by Member Campbell Rodriguez.
I won't suggest that she's distracting me. She was clarifying a point.
Let's direct our attention to Madam CPC.
Right. So, notwithstanding any possible overlap, I think the intention was to highlight these matters as examples that could constitute sufficient grounds for denial of bail. So, that being said, and listening to what was said, we could consider reversing the order. So, 3 would be 2. And what is in 2 would become 3, and it would start by saying, for the purposes of subsections 1 and 2, and then continue as is. And then to address the point that we deferred earlier in Clause 6 about including the factors that were listed by JFJ, just to tie everything together, what we could do in A is then to include the words at the end at the end of A to say, having regard to the matters specified in section 7.1 to 4. So I think that proposal would tie everything together.
Thank you, Madam CPC. So if the JFJ are listening, we would let them know that 2 of their recommendations will be considered and accepted in part, and that would reflect in redrafting, a tweaking of Clause 7.1b, taking into account part of what is contained in their recommendation on Clause 7 and also part of what is set out on their recommendation in respect to Clause 6.1 in accordance with the response of the CPC. And so it does, no harm is done to the policy intent, but the provisions are improved on based on the recommendations they have made. All right? All right, so so we'll say that the recommendation made in respect of clause 7.2 is partially accepted, and the CPC will revise the wording of the provision in accordance with her response. That's on the record. All right, good. Not by the alligator who makes the allegation. You see how you have been provoking all kind of things, Member Jackson. All right, let's just see where we are. 7.3. All right, let's just go up another 15 minutes, 15, 20 minutes, and see how far we go by then. All right? You'd still be out half an hour earlier than was communicated to you of our going up to 5. So let's just proceed. Miss Wilkins, that face says a lot.
No, I was so hopeful when Member Jackson spoke. I'm saying, oh my goodness.
All right, but it just means let me ask the CPC.
Well, there's definitely hunger.
Let me ask the CPC, because you realize that she left the virtual presence and came down, right? Let me hear what side she's going to vote on.
Yeah, not wanting to have further cement my reputation of being difficult or not being flexible, I would concur with the suggestion.
Is me throwing words after? No, I want to say for the record,
Yes.
the CPC and I personally have had a very wonderful working relationship for a number of years now. And I go further. She has been most facilitating when it comes to her office and matters that I have had to deal with. So we may differ on a particular point or on a particular provision, and that's the extent to which it goes.
I will say that between my role...
That's why I can take her throwing words at you very easily.
Between my role as Attorney General and now as the Minister with responsibility for the Office of Parliamentary Counsel, I can say that the Office of Parliamentary Counsel and the CPC have been given a bad rap. The CPC delivers timely, and many times complaints that are pointed at the Office of Parliamentary Counsel are unfounded, I have to say. And this is not to say there are no challenges. But today, the chair is outvoted on the adjournment time. And because the chair honors democracy, the chair will take the adjournment. And I know this is my team over there. Outvote me. Date and time of the next meeting, Madam Committee Clerk. No, tomorrow we're not meeting tomorrow. It's next. That's next week when? I think we're also now competing for some time. We have depending on I think the Standing Finance Committee and other committees will have to meet to deal with matters next week. So, 26? 26 is next week or the following week? Next week when? Next week, Thursday. All right. So, date and time of next meeting is Thursday, January 25. 26? Thursday, yes, January 26 at? It's 2 p.m.? At 2 2 p.m. And the next date after that? Because you know we're not finishing, so let's just lock the next date after that. Next 2 or 3 dates. We had indicatively set them out, but just to give members notice. No, man, that's a different process when it's just sent as opposed to when it's agreed, Member Jackson. Let me tell you what we had reserved. All right. 26, because, you know, we have other bills to come after this, you know. Right, I'm coming. Bill, my goodness. Yes.
On the 26th at 2 p.m., February the 1st at 2 p.m., and debate February the 8th and the 9th, passing of the bill.
Yes. So today is a Thursday. Hold on, please. Our next
Wednesday
meeting
the 18th,
will be the
Thursday the
26th. Thursday the 26th. And then we had a meeting on Tuesday. No, our last meeting was when? Last Tuesday the 18th? Last week, Wednesday the 18th, yes. Right.
Today is the 18th,
Right.
Chairman.
So our next meeting, will be... No, last meeting was when? 11th, okay. And today's the 18th. Our next meeting will be next week, Thursday, at 2 p.m. And then after that, February. Member Charles, just remind me, first, Wednesday the 1st? Yes.
We had Wednesday the 1st.
Wednesday the
at
1st,
2, and
yes.
then February the 8th and 9th. That's what.
Mm-hmm. Just let's, we have budget process. I know, yes. All right, so we have to consider other dates having regard to the prorogation of the Parliament that usually takes place early to mid-February. So let's just say that our next 2 meetings will next convene at 2 p.m. on the 26th, Thursday the 26th, and thereafter Wednesday the 1st. Between now and then, we will look at the other dates having regard to the other schedule in the Parliament. So next week is going to be 2 because there is another joint select at 10. 10 a.m., yes. No, first is 10 a.m. 10 a.m. Yes, 10 a.m. All right. All right. Let me thank everyone for your presence and participation, and also to the technical team.
My bail application was denied.
And you're well treated. Your standard of detention, your treatment in custody meets and exceeds the standards. All right, so we take the adjournment at 4:25.